Member Oak Bay Gordon Head.
Thank you, Honourable Chair, and thank you to the member opposite for the questions that will be asked for, and to the Minister, who I'm here with too. I'm here to introduce the bill M206 and to introduce my staff who will be helping me out with Claire Hume in the gallery there, along with Evan Pivnik. As the Chair will know, this is a rather unique process. What will happen here, and what we went through with the Benefit Corporation, is that I may have to confer with my staff off in the gallery, and the Minister may confer with her staff. I, of course, am not allowed to confer with the ministerial staff, but I can confer with the Minister. So there will be a rather interesting kind of dialogue and exchange here. So, well, we can feed the member opposite for some questions if he would like to see some as well. No, it's, anyway, this is. I'd like to start, Honourable Chair, by moving the amendment that's on the order papers. That amendment to Section 1 has been on the order papers for quite some time, and as if we look at Section 1, if we start with that. In Section 45.11 of the Residential Tenancy Act, we're proposing the addition of two new terms to be used exclusively in Section 45.1 and 45.2. What you'll see there is that, as currently written, 45.1L lists and defines the following: family member, family violence, long-term care, and long-term care facility. To that list, Honourable Chair, in the amendment, we're proposing the addition of household violence and a clarifying definition of the word occupant. Again, these terms are as defined for use in sections 45.1 of the bill and 45.2 of the bill only. Only the sections of that bill, not throughout the rest of the Act. Household violence is defined using the same definition that currently exists for family violence and the same definition we had in the first draft for occupant violence. And recall, a lot of this good work was done by the previous administration in 2015 when they brought in a bill to actually address tenancy and family violence. But instead, in our case, instead of only applying to violence perpetrated by a family member, it's expanded to capture violence in general associated with the home, perpetrated by a non-family member such as neighbor or a roommate, for example, as well. We're also proposing the use of the definition household violence as follows. Household violence means violence that has adversely affected a tenant or occupant's quiet enjoyment, security, safety, or physical well-being, or is likely to adversely affect those if the tenant or occupant remains in a rental unit, including A, physical abuse of the tenant or occupant, including forced confinement or deprivation of the necessities of life, but not including the use of reasonable force to protect oneself or others from harm. Sexual abuse of the tenant or occupant, attempts to physically or sexually abuse the tenant or occupant, psychological or emotional abuse of the tenant or occupant, including, but not limited to, or including rather, 1, intimidation, harassment, coercion of threats, including threats respecting other persons, pets, or property. 2, unreasonable restrictions on or prevention of financial or personal autonomy of the tenant or occupant. 3, stalking or following the tenant or occupant. And 4, intentional damage to property. And the final, in the case of an individual under the age of 19, direct or indirect exposure to violence against the tenant or occupant. And the reason why that's important, of course, Honourable Speaker, Honourable Chair, is that the violence may be to a child who's not actually on lease, but the child's parent may actually be an occupant in the household. The household violence is proposed as an amendment here to replace occupant violence, as written in my original bill that was in our binders, because of the feedback I received from the Ministry of Municipal Affairs and Housing and their legislative drafters. There was a concern, Honourable Chair, that using occupant violence could be confusing because of its overlap with the term tenant. For example, a tenant is an occupant, but an occupant is not necessarily a tenant. And this is what I'm sure the member opposite will be asking some questions about the process that led up to the amendments that came today, and I look forward to answering those if those questions arise. The concept, Honourable Chair, of a tenant is used extensively throughout the Residential Tenancy Act as well as in the Strata Property Act, but they can have slightly different interpretations depending on the context, so we decided it would be better to choose a new term altogether. And when I say we, it is in consultation with the legislative drafter that we worked with for several months on this file. Household, the word household was chosen because it is a term that refers to people who reside under one roof, which works nicely to capture violence associated with the house. I also like the term household because it reflects the fact that after a crime, one's residence is often no longer a home and certainly no longer a safe home. The other amendment members will note in the definition here is a tightening of the household violence subsections and the addition of an occupant definition. In the first bill we had, Honourable Chair, we wrote this. It said, of the tenant or other occupant, or a dependent of the tenant or other occupant, repeated in each line. This was viewed to be burdensome, and an example of that was physical abuse, quote, of the tenant or other occupant, or a dependent of the tenant or other occupant. This starts to sound like a bit of a mouthful, so what we did, again, from feedback through the ministry staff and their legislative drafters, who are separate and different from our legislative drafter, well, they made a recommendation to simplify it by just saying tenant or occupant, and in the definition subsections, we added some lines there to clarify that occupant means an individual who occupies the rental unit, including dependents of the tenant or occupant who live there. I recognize this sounds like a mouthful of words like tenant, occupant, and household, but again, we were working very carefully and closely with the legislative drafter that we had access to, and then we had the feedback from the legislative drafters associated with the ministry, and it was coming through some iterations we came to this in the legislation. The policy intent remains of the original one, but it's better organized now, and so I think this is a good change as it makes the section much more readable. Finally, I'm proposing we replace the term child with individual under the age 19. Again, that's for clarity reasons, to ensure people understand we are talking about youth, not adult children. There's a couple more changes in Section 1B of the amendment. We've also made a change there based on the feedback, again, from the ministry and the legislative drafters that they have access to, about the clarity matching with the existing language. And I'm proposing again in this amendment that we add in the word either to the start of 45.1 bracket 2 bracket A bracket II bracket to match the family violence section above. And the family violence section exists, and it was brought forward by the BC Liberals in 2015. Again, to match the simplifying change made to the previous definition section, I've amended 45.1 bracket 2 bracket A bracket II bracket to just say tenant or occupant, instead of listing out tenant or other occupant or dependent of the tenant or other occupant who lives in the rental unit. And finally, in Section 1C, we introduced an amendment there, Honourable Chair, to add a new subsection, Section 1C of this bill, and this, quote, for certainty, quote, subsection pairs with the language simplification changes detailed previously to clarify that for Section 45.1 and Section 45.2, the term occupant includes the dependents of the tenant or occupant who live in the rental unit. And this was an important thing that we were missing, is that in fact occupant could include the children of a tenant there, and the children may not actually be on title but certainly they're living in the domicile. We've added this subsection instead of listing the same information every single line. And with that, Honourable Chair, I thank you for allowing me to share these initial comments with the members in this room.
Member Nechako Lakes.
Thank you, Honourable Chair. And this is an interesting process. I actually didn't have the opportunity to go through the bill that came through earlier, and you know, there has been very few bills that have gone through. So I guess do I ask the question of the member moving the bill? Aha, yes, and then the minister may then at that point, if she so desires, enter into a few questions. Like I say, it's an interesting process because as a legislature, we don't tend to move forward private member bills. The process tends to be, if a private member bill comes forward, government adopts it if they want to move it forward, and then moves it as a government bill. And so this is unique, and it's actually one of the things I think that's kind of, you know, as much as I find being in opposition not exactly to my taste, the current circumstances have allowed for a few of these types of situations forward. So it is an interesting process. So and I want to congratulate the member in terms of bringing this forward and through this, and obviously working through the Secretariat, there must have been some discussions and process that would have gone on with government in terms of the ability to bring this forward. So I guess maybe just an initial question, if I may, Honourable Chair, through to the member, is as you move this bill forward, as this process was developed, how did that conversation, how did that work actually go on between, and I realize that's not in a section of the bill, but I'm curious, right, in terms of how that work actually went on between government and the process that went on to go back and forth in order to actually draft the bill and have it come forward.
Member Oak Bay Gordon Head.
Thank you, Honourable Chair. First off, I wish to acknowledge that, in fact, the previous government did do precisely what the member did. In the case of a couple of my private members' bills, the government recognized that they supported the intent and they brought in their own bill, and credit to government for doing that. So there has been precedent, but it's not been done this way, and it's kind of unique this way. Both the Minister and I will answer because we have different perspective. It's a very unique process here. Is what we do not have access to the ministry staff or the ministry legislative drafters. However, government, for the first time, as far as I know, and if ever for a very long time, has given opposition members access to legislative drafters. We have access to a legislative drafter who we have got our amendments and worked our bills through. So the process came is that my staff and I developed the concept that we wished to be put into legislation. We went to our legislative drafter. We had a back and forth between our office and the legislative drafter until we got what we believed was a good first draft. What we will see is that draft then appeared on the order papers. Government has, looking at it then, government staff, government lawyers, government legislative drafters then have a look at it, and they made recommendations to us from their perspective, because what our legislative drafter and their legislative drafters are not even allowed to talk to each other in this process. It's very distinct processes. Yeah, so our legislative drafter is worked with us exclusively. Their legislative drafters looked at it and gave recommendations to us. We then discussed it amongst ourselves, staff, me and staff would go back and forth with the legislative drafter. We put forward another, some ideas, and then, we got some recommendations back. And so there was a bit of back and forth in terms of recommendations. Government at no time did their legislative drafters insist or require we change anything. At all time, all they did was make recommendations that our legislative drafter took to make recommendations to us. So it was a back and forth process. The Minister and I don't think we talked about this. It was all done between staff and legislative drafters through staff. In the end, I put the amendments that we came to agreement through our legislative drafter via our staff to the ministry staff to their legislative drafters. There was some sort of recognition that we felt comfortable we had addressed their recommendations. Government at this point pointed to us that they felt supportive of the intent and this bill, and we put the amendments on the order paper. As you can see from the order paper amendments, they're extensive, but they're not substantive. They're extensive in terms of changing the definition of occupant violence to household violence, and shortening language, and also reflecting upon the issue of the children who may be associated with a tenant who is in the house. So the process it actually works. It's interesting navigating. It worked very well. We had a very good relationship with our legislative drafter, and the interaction was good, and it led to where we are today. But I don't know what happened on the ministry side, so I'm going to appeal to the minister to see what happened there.
Minister.
Thank you. Being part of a government that's doing things differently is really important to me, because I think at the end of the day, for our government, it really is about what do people need. And so here was a private member's bill that came forward, and it was this piece of legislation sits in my ministry, and it became a discussion around do we, as government, do you, as minister, agree with this direction? And it fits within our focus and our frame in terms of what we're aiming to do, which is to make sure that people's homes are safe for them. And this strengthened a piece of legislation that the previous government did. So from our perspective, it was, shall we work with them in order to deliver this? This is something they want to deliver. And it was like, okay, what's the process? And I think it was created as we went along in terms of identifying how to best move forward. And there was sort of regular feedback. It would go through the sort of the Green Caucus, and then it would come down through staff. They would do their work, and it would come back up to the ministry. But really, I want to acknowledge staff from the residential tenancy branch who have been absolutely outstanding in helping to co-create a method for bringing forward a private member's bill so that it would work, and here we are today.
Member.
Just one clarification to my words. I think I used the word recommendation, and I think feedback would be a more appropriate word. I tried to do recommendation with the understanding that no time did they require us to implement. It was really a point of feedback, so I thank the Minister for using that word.
Member Nechako Lakes.
Thank you, Honourable Chair. And you know, like I said, I'm fascinated with this process because I've moved forward a number of private member bills, and I have never really even thought about the you know, actually trying to figure out if we could do this jointly with the ministry. Of course, because in your opposition, it's a little bit different in terms of the process of going through. But I'm curious, and if I could, Honourable Chair, through you to the member and to the minister, I'm really kind of curious, why wasn't there able to have the direct or legislative drafters involved in it? It's just, I get the, you know, the government, you know, and because I've used legislative drafting as well, and having people made available to help with drafting a private member's bill, I get that. But what I don't get is why there needed to be the division. It doesn't seem to make sense to me. But so if I could just ask for some clarity on that.
Minister.
So I will do my best because it's not my area of expertise. And so I am going to assume that this may have something to do with out of the AG's office in terms of when you work for government versus not, and how supports happen and play out. But I can do my best to get a more specific answer for the member. Again, we need to, I think, remember that this is brand new. And we're all sort of feeling our way around how can we do this in a way that might be more efficient. I think there's some learnings that we're doing around how can we do this more efficiently. But this was the process that was set up as best we can, given that this is brand new. And so using the existing structures and trying to adapt and adopt a new way of delivering good legislation, we're feeling our way as we go through. And so this was the process, and I expect that there'll be some ongoing conversation about are there ways that we can make that work better.
Member Nechako Lakes.
Thank you, Honourable Chair. And I want to thank the minister for that answer, and that because, I mean, having been in government not that long ago, you know, I fully recognize that government resources need to be spent on government activities, and there's definitely a line. It's even a line with private members within government, let alone private members within opposition or within, I guess officially your opposition. So I get there's that sort of challenge on that, and so that's an interesting point. I guess we'll need to find a way to think about that in terms of where the resources, how those resources are spent, I guess, because I do think there's some ways to be able to be more efficient in terms of how we can move forward private members, and which I think, quite frankly, can add some value to the work that everybody does within the legislature. And so, you know, I commend you in terms of finding a way through this and working on this. Love to be part of a conversation about how we actually expand that out to making it perhaps even more efficient in the future through what that does. So, in terms of the process and the back and forth, I am a little curious. So, the member obviously had gone out and talked to a number of groups and would have been through some sort of engagement process before coming forward with this sort of bill. So I'm just wondering if the member, you know, in coming up with the suggestions in here, could perhaps talk a little bit about the process that he went through, you know, in terms of input that would have led to this and bringing forward this bill.
Member Oak Bay Gordon Head.
Oh, thank you, Honourable Chair. Two things. First, to address the member's comment about the process, I think I would just like to give an example, just for illustration in case people are watching, is that yesterday the member from Chilliwack, actually a member from Shuswap, brought forward an amendment to Bill 20, Bill 30, the Labour Code. That amendment had been prepared by legislative drafters that were made available to government. Because the amendment was actually put and developed in a manner that was consistent with legislative language from all acts, it's something that produced a very strong amendment that allowed our caucus to support the amendment brought forward yesterday. So, I mean, I think your government deserves, the minister's government deserves a lot of credit for making available to opposition members legislative drafters, and I think the members of the official opposition as well as our Green Caucus have taken advantage of that. And with respect to the process, the two main groups that we consulted consulted were the Ending Violence Association of British Columbia and the West Coast LEAF, where LEAF is the Legal Education Action Fund, both of which are extensive advocacy groups, and both of which were very involved also and consulted by the BC Liberals in 2015 when they developed the family violence provisions in the Act that we're extending. Again, it was the similar process. We reached out to them and asked them. They're extensively involved in ensuring that basically we're moving on a path towards ending violence, and they were the key people in terms of a broader engagement for us in terms of how we were getting a sense of what the issues were, and they provided us some examples of why this is important.
Member Nechako Lakes.
Thank you, Honourable Chair. And I do actually have a fairly keen interest, although I didn't get an opportunity to speak in second reading to this. And you know, spending time as the minister for at that time was called Aboriginal Relations and Reconciliation. I mean, there's significant violence in homes. You know, both within Indigenous communities, but also outside of Indigenous communities. And you know, I have worked closely with women's shelters in my riding, trying to get support and through that process. And so, you know, I've talked with them about a number of these things. And you know, women fleeing violence in particular is you know, is a significant concern. And the idea, you know, in terms of the Act, in terms of this stuff, I think is it's good to be able to have these definitions in there. But there's also, you know, there's obviously some pretty unique situations that happen out, you know, certainly in my riding, unfortunately, and in many other ridings, and having a chance to talk with many family members, from many people, particularly from a session I did with families of missing and murdered women. From along Highway 16 as well as around the province when we did a gathering, and had a chance to hear many stories and components around it. And so I guess the question on it, and you know, many of those issues, of course, aren't dealt with in here, because those are issues that are, you know, in other pieces of legislation. But certainly when it comes to tenancy, I found many people found themselves trapped in situations because they didn't know where to go, they didn't know what to do. You know, they're in, whether it's verbal abuse, whether it's sexual abuse or violence, or you know, these types of things. It becomes it's a pretty challenging issue, and it's, you know, particularly for First Nations. I mean, it's a very challenging issue with that. And so I guess that's why I'm sort of asking. And the groups that you mentioned obviously are very connected with that and those parts of it. But in particular from that perspective of you know, on reserve people living in these situations, did you get any feedback or components around that as part of how you developed this bill?
Member, Member Oak Bay Gordon Head.
Thank you, and thank you to the member for that very important question about consultation with broader Indigenous communities. What we did, as I mentioned, is go through the Ending Violence Association of British Columbia and West Coast Legal Education and Action Fund. These are two organizations that have extensive experience working with Indigenous and other marginalized communities where we accept that some of these problems that we're trying to deal with are often amplified. One of the things that I think is important to also add here is that when the former government brought in the family violence legislation in 2015, they created a very fine suite of regulations attached to it. They spent a fair amount of time extensively consulting more broadly to, in particular, come up with the types of people who may make a family violence confirmation statement. The idea here is, you'll see in the legislation, that there are certain professionals that are able to make family violence confirmation statements. They're individuals which, for the purpose of this discussion, the two key aspects of that is an employee of, quote, one, an Aboriginal organization who is responsible for duties as a family support worker, executive director, Aboriginal court worker, or Aboriginal justice worker, or two, a First Nation or the Métis Nation, British Columbia, who is responsible for providing support or services in respect of children, families, justice, housing, or health. So our approach to this was to go to the advocates who have extensive experience working with communities, both Indigenous and other communities, as to seek their advice, extensive advice, and also to recognize that the government previously had done extensive consultation in terms of setting up the regulatory environment. And we, as you'll see in the legislation, agree that this is a very good foundation. And in fact, we believe that the Section O of Part 7 end of fixed term tenancy in the Section 39 of that, called eligibility to confirm risk of family violence in the residency tenancy regulations, and in Section 39O, an employee of, is very fine language that gives Aboriginal communities the ability to use local support workers, or court workers, or justice workers, or the Métis Nation to actually be the person making the statement to allow for the lease to be broken.
Minister.
Thank you. I do have an answer to the member's previous question about the use of legislative drafters, and it's about the client solicitor privilege, that the legislative drafters, the client is the government and not the opposition, and so everyone has their own relationship, and so that's why it's set up the way it is. So the solicitor, the client, the drafters, their client is the third party. So that's the frame, and that's why it's broken down the way it is. But I also wanted to make mention, the member asked about and commented specifically about Indigenous women, and we know that the risk for Indigenous women is significantly greater than it is for other women. And that's why our government has taken a number of steps around, first of all, significant funds for women fleeing violence, women and children fleeing violence. I was just in Penticton, for example, with opening up homes for women, and the stories that I heard were quite astounding. In fact, there's one woman in particular who told the story of her husband just locking her out with their infant son and not having any place to go. And so was grateful to have the opportunity to set up a home so she can raise her child. The other thing that we've done, of course, is housing on and off reserve, and that really just gives people certainly a home where their community is, and that was a significant announcement. We're still the only province to have done so. And again, we know that when there are multiple families living in a home on reserve, we know people are crowded. There's terrible overcrowding, and we need to find a way to deliver the kind of housing that people on reserve need, and so our government is doing our part to help relieve some of that burden.
Member Nechako Lakes.
Thank you, Honourable Chair, and I actually want to As an opposition member, sometimes you don't get a chance to say this very much, but thank the minister and for the investments in that. You know, as when I had the portfolio for over 4 years, obviously, with the stories, with the circumstances, you know, I'm appreciative of anybody, any government that has an opportunity to step up to the plate and to be able to help address these situations. Some of those particular circumstances that people had enough confidence to share in with me were pretty horrendous. And so, you know, anything that can be done to help try to alleviate and change those circumstances, I think is good. And so, you know, to that end, that's why particularly I asked the question around engaging on the Indigenous side, because the numbers are significantly higher than they are in the general population. And so for making changes, you know, we want to make sure that it can work, and it can work effectively for a population that really needs it. You know, the side circumstances, of course, that come from not having a safe environment, not having a safe, whether it's issues within family, related family members or others, right, is, anyway, yeah, I get kind of emotional in talking about this because it is that such. I mean, it's quite remarkable when I think back on some of the stories, and I wish there was a way I could actually share some of those stories more publicly, simply for the reason that, you know, more people need to hear about these things, but they're not my stories to tell, so I can't go off and talk about that. But so in terms of this act, in terms of the changes that are brought forward and the household violence and these side of things, and that, you know, I'm thinking about particularly the occupant violence. Sometimes there can be blurred lines around that, and so I'm just wondering, you know, are you satisfied in terms of how that's defined, or do you think there's any potential loopholes that could come, given the circumstances? And often, you know, in a situation on reserve, there can be multiple families, there can be overcrowding, there can be situations that can lead to these sort of challenges that, you know, this bill, I hope, is designed to try to address.
Okay. Member Oakbed, you were heading to this chair, I thought.
Yeah, so in order to get to this chair, I must stand to go over there, and when I am
All
standing.
right, Member Oak Bay Gordon Head.
Thank you, Honourable Chair. Honourable Chair, through you to the member, in Section 1, Article 1, there says there's a very key word here that is the word including. It says there's a definition of household violence, and it says this, means violence that has, let me get the version that's as amended, just so I can ensure that I don't mess it up. as amended, it would, if the amendment passes, it would say means violence that has adversely affected a tenant or occupant's quiet enjoyment, security, safety, or physical well-being, or is likely to adversely affect those if the tenant or occupant remains in a rental unit, including. Now, the key word there is including, because it provides by using the word including, it provides a list of situations covered by the term family violence, as is also used in the definition of family violence. Now, family violence, of course, exists in the existing bill. That was what was brought forward by the BC Liberals and passed with the support of the House in 2015. So we've built upon that. The law is kept inclusive of a range of situations that could fit the broader intent rather than explicitly specifying which situations would be covered and risk unintentionally excluding. So by having the word including, giving a list of examples, but recognizing that there may be some that down the road others might find, but this is we might have not been covered in the actual including. This is precisely why, Honourable Chair, it's so important to move towards the regulations, which I touched upon earlier. And again, these regulations in the existing Act were brought forward after extensive consultations by the previous government with reference to the family violence provisions. So we have in that extensive consultations in which Indigenous communities were included. It was very important and critical to ensure that the experts who could provide the testimony were relevant to the communities on which the violence was occurring. So we commend the previous government for doing. We've done this several times for really extensively canvassing the type of professionals who should be involved in making recommendations with respect to breaking a lease. The Aboriginal components in there were brought or carried forward into this legislation. So we believe that it's inclusive. We believe we have the right regulatory framework in place already. However, under Section 3 of this Act, you'll see that there's a time period as proposed to be amended. And the idea is that government may go through a consultation process and find that there are some other examples what we might have to consider. So the enabling legislation, the regulatory environment is enabled here would also allow government to come up with some other examples as the civil service does their work, if they find some. So we're quite confident we're capturing it. But again, just like in 2015 in speaking with members at the time, I think this is, we build legislation, and if gaps are found, I think down the road, I'm certain based on the support we've seen on this type of thing, we'll get to fixing it collectively.
Member Nechako Lakes.
Thanks. I actually wasn't too sure how the process is whether if the minister needed more time, whether I had to get up again or whether it was wait for the minister. So anyway, like I say, it is fascinating to watch. But anyway, so I want to, through you, Honourable Chair, through the member, thank you for that answer. And I am happy that I see the wording here using including. Including is good because that means it's not excluding, right? If there's something that wasn't necessarily in that list, and that is helpful in terms of moving through. I'm a little bit curious though, just in terms of the situation, and one of the things that comes to mind sometimes in environments, whether it's with Indigenous people or not, is you may have somebody in a home that is an occupant, may not be signatory to rent, and may just kind of be there legally or otherwise. And so I'm just curious in terms of how that sort of situation comes about. If somebody's there for a period of time, that may not be a tenant, so to speak, may just be somebody in the thing, how that is dealt with associated with this bill.
Member Oak Bay Gordon Head.
Thank you, Honourable Chair. To address the question, there is in the amendment a definition of the word occupant, and that definition means an individual, it's a clarifying definition, means an individual other than a tenant who occupies a rental unit. We'll come to that in a second. So now if we then, what does occupy mean and what does occupant mean? Well, occupies, as used in the definition of occupant, has the ordinary meaning here. It's commonly used in the Residential Tenancy Act as it is, and also the Strata Property Act, as its existing statutes, to describe someone who lives in the unit. However, these amendments do not cover violence towards guests or visitors. So if someone is considered to be an occupant as to the regular meaning in use already in the Residential Tenancy and Strata Property Acts, they'd be covered. However, a guest, someone who's perhaps visiting you for a couple of days, would not be considered an occupant, and they would not be covered under the Act and, based on the normal use of the word occupant and occupies.
Member Nechako Lakes.
Thank you very much, Honourable Chair. So, and I'm curious about that, just in terms of occupant, and I apologize because I don't have the definition here in front of me. Just in terms of what length of time before someone changes over from being a guest to being an occupant. And the reason why I ask, of course, is because you can get some very interesting situations that happen, and that I've heard with particularly with Indigenous communities, but in other communities where you maybe have a situation where a brother or uncle or a friend is being invited to come in and stay for a while, and a while turns into potentially many months. And so I'm just wondering how that works.
Okay, Member Gordon, Oak Bay Gordon Head.
Thank you. I don't want people to change the channel at home, so we want to give them something to listen to it as the minister is consulting. I just wanted to address the members' questions about process. On this bill, anything that's with respect to the bill, I will try to address as best I can. I am unable to go and talk about the broader implications. So this particular question refers to a time with respect to the regular use of the word occupy. That reflects to the use in the Residential Tenancy Act and the Strata Property Act, which requires the minister to speak on that behalf. So she will answer this question.
Minister.
And I have an answer. We have third-party verifiers, and they make that determination because each situation is unique, and so it's based on the existing regulations, and that's the process that has been developed that's being used.
Member Nechako Lakes.
Thank you, Honourable Chair, and I want to thank the members, both members, for the answer. And it's just, as you can see, right, I mean, as I'm working through and thinking about the situations, and, I've got a number of situations where there have been these sort of issues have been raised in my office, which is why I'm asking specifically about these. It's one thing about, being an MLA, particularly in a rural area, but really in all areas, your office tends to get engaged in many, many different circumstances. And so the clarity on that is helpful, just in terms of, I've had people come in and ask, how do I deal with this situation? And so anyway, that part's good. And just a little bit of follow-up in terms of, when you go through the list, one of the things that's in here that I kind of wondered about was where it talks about stalking or following a tenant. Is there a measure, or is there a process that sort of has a reasonableness or a fairness perspective in terms of what that would constitute?
Minister.
Well, no, I'm not gonna wait for the other member because I have an answer, because I think,
got another
and he can have another answer. We'll see if it's the same answer. But staff tell me that it's consistent with the Family Law Act, so they just took it right from the Family Law Act and they've imported it into this act so that as government, we're consistent.
Member Nachuk, no, Member Bay Gordon Head.
And I could provide some value-added commentary to the minister's response. In fact, there is a criminal definition of stalking. The offence of criminal harassment or stalking generally consists of repeated conduct that is carried out over a period of time and which causes those who are victimized in these ways to reasonably fear for their safety. The criminal behavior does not necessarily result in physical injury. So there is actually a formal criminal definition of stalking, and as the minister mentioned, this is consistent with the Family Violence Act.
Member Nechako Lakes.
Thank you, Honourable Chair, and I appreciate that. It's good. I just, you know, one of the communities that I represent, there's been cases where information has come forward and has not actually been able to play out because of circumstances, whether it's proof or otherwise, and so that's why I'm sort of asking about that in terms of sort of where that line may be, and so if that line is the same as it has been in the other laws, that's good. I kind of assumed that would be the case, but I just wanted to make sure, not so much on the stalking, but just on the following side, right? Because you do get these situations where sometimes a family member will be, or a friend, or perhaps somebody who used to be a friend will make an accusation and base it on various components, and you never know. Sometimes those accusations, of course, don't follow through in terms of getting to a place where somebody is actually held accountable for that sort of thing. So, like I say, that's why when I just went through it, that was one of those things that stood out for me when I went through the bill, and I just wanted to be able to have the clarification around that. And so, in the situation, you know, and I'm trying to think about through the amendment that you had in the situation that I've outlined. So it is not exclusive; it's inclusive in terms of the process going through. There will be regulations, or the potential for regulations to be made through this process. Is there going to be a process in terms of those regulations similar in terms of the engagement and discussion? And, you know, once again, obviously there'll be lots of people that'll be very interested in this component. There's many groups that are engaged and concerned on this side. So just wondering how that process will go through so that people don't have a sense of there being an exclusion or something that might be missed.
Minister.
Thank you. You know, we would absolutely consult and perhaps build on the work that's already been done and undertaken in order to make sure that we can cover off as much as we can as part of the regulation. It's really important that we consult with these groups and others so that we are as inclusive as possible, and that we can make sure that this works, because at the end of the day, it really is about the people, the people that find themselves in dangerous situations and in frightening situations or in unsafe situations. We want to make sure that they have the ability to get to safety, and this is another way to do that. So we want to make sure that we're as broad as we can be, and consultation is a key component of developing those regulations.
Member.
Thank you, and I'm glad to hear that. That's an important piece. Just curious as well, though, in terms of issues of mental health, these types of things that can happen, that can sometimes be viewed from one perspective, but may not be because of the situation. So I'm just wondering how that plays into the definitions and the process that is outlined here in the bill.
Member Oak Bay Gordon Head.
I'm wondering if we might get some clarification from the member as to what he means with respect to the issue of mental health. Is the member asking about what would happen if a tenant was undergoing a mental health crisis, or is he about a perpetrator who may have mental health issues, or an occupant who may have mental health? We're a little unclear as to what the member is meaning with respect to mental health.
Member Nechako Lakes.
Thank you, Honourable Chair. I was referring to an occupant or tenant in terms of that may have a health situation, a mental health situation that could create an environment that may not necessarily be threatening or otherwise, but may be perceived that way, and just how that sort of thing would be handled.
Member Oak Bay Gordon Head.
Thank you for the clarification. Through you, Honourable Chair, to the member. In the Section 1 definitions, there is something there that talks about psychological or emotional abuse of the tenant or occupant. So let's suppose hypothetically that there are two people sharing a lease, and let's suppose they're two students and they have a two-bedroom condominium and they're both on the lease, and one of the students suffers some mental illness that makes the other student feel very unsafe. The other student has the ability to go to the third-party validators such as counselors, mental health professionals, psychiatrists, to seek an opinion as to whether or not this would allow them to break the lease. So it is, if they get third-party validating certification, they would be able to break the lease because of a perceived threat under Section 45(1)(d) with respect to psychological or emotional abuse, or it could actually be a worry about a threat of violence. Let's suppose hypothetically there was a concern that a student with you would stop taking medication with respect to schizophrenia or something like that. You might imagine that you might feel unsafe on a lease, and a third-party validator would allow a person to break a lease. So we believe it's captured in the existing definitions.
Member Nechako Lakes.
Thank you, Honourable Chair. And I'm chuckling a little bit on this. Is obviously a very serious issue, but the first thing that came to mind, of course, was Big Bang Theory, right? But besides that.
I started off in particle theory.
No, you did? Okay. I'm sorry. Yeah, no, okay, maybe I won't go there, Minister, but that's okay.
Let's talk about forks.
Sorry, my apologies, Madam Speaker. This is obviously a very serious issue in terms of it, and a little bit of humor as we go through this process is always nice to be able to do. But I certainly don't want anybody taking it out of context in the seriousness of the issue. And so, in terms of going through, it looks like this has gone through and been able to capture, the circumstances certainly that I have run across in my time and privilege of being an MLA, and certainly the issues that I've dealt with as being minister, and the kind of things that were brought up. So I'm happy to see that is in place. And so I don't think I have any other questions on Section 1. So thank you.
Member Oak Bay Gordon Head.
I just want to formally acknowledge how important I think it is to bring humor into discussions like this. So I appreciate the candor. It is a very serious issue. I agree with the member, but when the member referred to Big Bang Theory, it brought back just as many memories to me too. So thank you for that reference.
Seeing no further questions, shall the amendment made by member for Oak Bay Gordon Head pass? All those in favor? Aye. Opposed? Carried. And shall Section 1 as amended pass? Aye. Opposed? Carried. Oh, sorry. Member Oak Bay Gordon Head.
Thank you, Honourable Chair, and thank you to the patience of the member opposite as I introduce an amendment to this section. The amendment to Section 2 has been standing in my name on the order papers for quite some time, a couple of weeks now. So what the amendment does is as follows. The original intent of Section 2, Residential Tenancy Act, Section 45.2 in my bill, was to extend a person's authority to make a confirmation statement in relation to family violence to include the authority to make a confirmation statement in relation to household violence as well. The amendment still accomplishes that policy goal, but again, with different language that aligns with the feedback that we received from the ministry. Instead of specifying that, and I quote, if the regulations do not provide for the making of a statement under the section in relation to household violence, a person's authority under this section to make a statement in relation to family violence is deemed to include the authority to make a statement in relation to household violence. My staff have talked extensively with Ministry about adjusting Section 3 to build in the time necessary to consult and adjust the regulations directly, which would make this section, as I originally drafted it, essentially redundant. And so we accept that in this amendment, text is added to the end of Section 45.2 bracket L, is that L or 1 bracket? 1B, to clarify, if it was written as an L, I can assure you, a few years from now, there'd be a very fine legislative drafter who would pick up the error and we'd have a missed stats bill, because we actually changed one of those recently, Honourable Chair, an L to a 1, or vice versa. In this amendment, the text is added to the end of Section 45.2 1B to clarify that for household violence, the occupant and occupant circumstances can also be considered by the third-party validator when they are evaluating the tenant situation. For example, Honourable Chair, if your roommate or child is attacked by your neighbor, even though it is not specifically about you as the tenant, it is reasonable to expect you may need or want to leave a safer home. And so the amendment that I'm proposing is as follows. It reads this: 45.2, right, 1, a person may make a statement confirming a tenant's eligibility to end a fixed-term tenancy under Section 45.1 only if the person, A, is authorized to do so under the regulations that we referred to earlier, and B, has assessed in accordance with the regulations the tenant and the tenant's circumstances and, this is new, and, if applicable, in respect of household violence, the occupant and the occupant's circumstances. So here the amendment's supposed to, is clarifying, tightening, and ensuring that it's inclusive as well.
Member Nechako Lakes on the amendment.
Thank you, Madam Chair, and I have no real concerns on the amendment. The amendment's fine. I'm actually just curious about that, once again, about the process with the legislative drafters and just that process that went on and how that came about. I guess, you know, I understand the legislative drafters' job is to put forward that, but I'm just wondering, wouldn't there be a better way so that wouldn't have to have that going back? So I just want to ask a little bit about that process and how it came to this amendment to change.
Member Oak Bay Gordon Head.
Thank you, Honourable Chair. I'll go through the process. It's very similar to the previous process. So, of course, we put the bill through that process that I won't go through onto the order papers after we consulted with our legislative drafters. It's at that point that ministry staff and ministry lawyers and ministry drafters were able to see what we entailed, and they provided feedback. One of the things we did there is we felt it was the regulatory environment that was brought in place by the former government associated with family violence was very strong. We wanted to ensure, we felt that that language and that regulatory environment could carry right across into household violence. So what we did initially is ensure that if government didn't come up with a regulatory environment this one would fill in. So we would ensure that there was a default, which in essence was what was already on the books applicable to family violence. However, my understanding is consultation between staff was that government agreed that the regulations that had been brought in place by the former government were very strong, and they believed that it was a foundation on which to build as opposed to one with which to replace. And we accepted that, and we thought this was no longer necessary and hence redundant, and so removed that by simply clarifying. So it was really a process of us putting the bill on the order papers, the government looking at it, providing us feedback, us responding to that feedback, a discussion about the importance of the regulatory environment brought forward by the previous government, agreement by both government and third party that these were the foundation, not something to be removed, and so the text was redundant.
Member Nechako Lakes.
Thank you, Honourable Chair. And I want to thank you for that explanation. A procedural question, if I may. I'm just wondering, and we talked about this a little bit before, but do you actually have to have it on the order papers as a bill before the legislative drafters, the ministry's legislative drafters can look at, or is it possible to provide a draft and through a process? I'm just wondering if it has to actually be on the floor before you can get that input.
Member Oak Bay Gordon Head.
So our procedure we were identified as we tabled at first reading the bill. So I stood at first reading and tabled the bill. It was that time that was government's first time that government saw the bill. Because of the fact that our legislative director that we have access to cannot, because of, I guess, its client privilege, cannot interact with the government legislative drafters, the communication between them did not occur until after, well, it really never occurred directly between them. Our communications only took forward once our bill had been tabled at first reading, and it was through the feedback and ongoing discussions with ministry staff and our staff that led to the amendments put on the order paper a couple of weeks ago. That was us, and it was only at that period that we knew what the feedback from their legislative drafters were relative to our legislative drafters. I tend to agree that perhaps maybe there's other processes involved, but this seems to have worked. I mean, it seemed to have worked well. It was very collaborative. It was very consultative. It was very rewarding, actually, to get the feedback. And honestly, I think by having a diversity of views on the same piece of legislation and feedback from multitude of legislative drafters, I think it led to a tighter and better piece of legislation.
Member Nechako Lakes. Thank you, Honourable Chair. And I agree with the member, actually, and I think the process going through. The question I had, though, was just whether or not there was another way to do that, whether or not there was a way to be able to provide the minister with, a draft copy to potentially look at, and whether or not there was any potential to do some of that work. And and not that it can't be done this way. Obviously, this can be done, and this, bill can be moved forward, and amendments can be brought forward, and this kind of stuff. And I'm just wondering if there was a way to be able to have that collaboration sort of as a process before it was officially on the floor, just from a technical perspective.
Minister.
Well, I suppose one way that could have been done more efficiently is to introduce it as a government bill, right? And then we just have government legislators, we bring it by. The intent of the bill still is kept whole. This was a different exercise and a different understanding and agreement around that this would be a private member's bill. And so, again, because we have this division of solicitor-client privilege, it's about keeping it separate, because the government legislators the legislative writers work for government, and government is the client, and so they can't work for both opposition and so that's why it's separate. But I don't disagree that maybe there is another way. I don't know. This is, like I said, the first time, or this is the second time that we're doing this session. But the most efficient way, I think, is for government to say, well, let's just pull it into a number of changes that we're doing, and let's just add it in and continue the consultation. Is this the intent? But that we only use one set of legislative writers, drafters who do it, and that would be the government drafters, because of course they have the history, they're most familiar, they have the broad, they're special folks who know how the Residential Tenancy Act, they know it well, they know how it interfaces with all the other acts, and so that would be certainly is to just have government do it and use resources a little bit differently.
Member Nechako Lakes.
Thank you, Honourable Chair, and thanks the Minister for that. And that's why I was just wondering, so I guess that if it had have come forward from a private member to the Minister, and the Minister and asked the Minister to have a look at it, in order to do that, it would have basically had to become a government bill, which is unfortunate, of course, because there's a lot of work and effort that goes into it from private member, whether it's Green Party or others, or other members in the House, right? And the recognition obviously needs to be there, or wants to be there, right, in terms of that work. And you're working hard on behalf of constituents and issues that come up, and so I get that. Okay, so anyway, I just wanted to understand that better in terms of why that couldn't have happened that way, and so I really appreciate taking that question and providing an answer. Thank you.
Seeing no further questions, shall the amendment of Section 2 put forward by Member for Oak Bay Gordon Head pass? All those in favor? Opposed? So ordered. Shall Section 3 pass?
Section 2 is amended.
Oh, right. I didn't do that. Sorry. So shall Section 2 as amended pass? Aye. Yes, please. So ordered. Shall Section 3 pass? Member from Oak Bay Gordon Head.
I thank the enthusiasm from government members who are, yes, yeah. So at this point, Honourable Chair, I'd like to also move an amendment that's on the order papers. You'll notice that Section 3 amendment has been on the order papers for a couple of weeks. It's basically deleting the text shown as struck out, that is deleting the text on the date of the royal assent, and changing this to say the Act comes into force by regulation of the Lieutenant Governor and Council, or on the date that is 1 year after the date of royal assent, whichever is earlier. Now, this may seem to be somewhat unique, and it is unique in the BC context to amend it as such, but this type of commencement language is actually quite common with bills in the Senate federally, as well as with the, in particular, opposition bills, the Senate and the federal Parliament. The idea here is that we have a very different process federally for debating private members' bill than we do provincially, and we're kind of learning it here as we move forward provincially. So the idea here is that we recognize that government needs to take some time to reflect upon the regulatory environment, so do some consultations. That will take some time, but there's the 1 year is a backstop. This is an important issue. It's a very important issue for a large number of people, and so the 1 year backstop means that government has a full year. We believe that's entirely reasonable. To bring it into force, to do the consultation and make any regulatory changes, and that's why we have the backstop at 1 year. Otherwise, it's just order in council, which is a typical thing that we see on most bills here in British Columbia.
Member Nechako Lakes.
Thank you, Honourable Chair, and I think it's probably the first time I ever stood up and asked a question about commencement. And it's yeah, exactly. It's our first. So it's a dawning of a new age. But I am curious about this because I have never seen this in in the years that I have had the privilege and honour of serving my constituents and being in here debating bits and pieces of legislation. I've never seen one that has had the either or that a 1 year sort of thing. So I guess I could see in the potential situation where you didn't want to lose the bill or have the bill kind of get hung because maybe there's an election or a change of government or these types of things, and so have that in there. But But I also, of course, see it's implemented by regulation or through order in council, with Lieutenant Governor and council. But I guess the question is, the bill as it is, there's regulation that can be created, regulation that can be put in place, obviously, and needs to be put in place, and there's consultation and work that obviously will be done around that. Why is there a need then to actually have the division here as opposed to just having that passed upon royal assent? And I'm just wondering, because if it's passed upon royal assent, the government still has the ability and the need to be able to go forward and create the regulations and the process that's happening. So I'm just wondering why that was put in.
Member Oak Bay Gordon Head.
From our perspective, we felt we wanted to give government the time to develop the regulatory environment. It's more difficult for us as an opposition caucus to know exactly what's entailed in terms of the regulatory environment. Our worry by putting it at royal assent is we would have not given government that time. But the member is absolutely correct about the rationale for a year is, again, it comes from the federal Senate and federal Parliament, and it's very common there for private members' bills to have that clause. And the idea there is exactly as the member identified, is if government, but let's suppose hypothetically the election happened, or let's suppose there's a change of priorities and this falls on the back burner, the 1 year actually is a backstop there. So we just wanted to give government the time to do the background. That was really the rationale why we did it, and I think it's a part of collaboration. We didn't want to force them into something. We wanted to allow them to reflect upon it and bring it in on a timely fashion. And there is an element of trust there. I recognize that, but we also have the 1 year backstop.
Minister.
Thank you. I have a couple of responses to the member's question. And the first one is we need to remember that this is about people, right? Yes, it's a piece of legislation that the member from Oak Bay Gordon Head worked really diligently on, and with his staff, and I want to thank them for their work. And so we need to make sure that, what does it mean for people? So the concern when you bring it in on royal assent, people think it's already in place, when in fact the regulations haven't even been formed, and there's still some work to be done. So this is a way to sort of say, we're not quite there yet. It's a law, but there's still some regulations. In order to make sure that everybody understands how to use this, we need to make sure that we have the regulations. And we certainly, I know that there was some discussion about the 1 year and the regulation, and I can appreciate wanting to make sure that there's a backstop, but we're committed as a government to make sure that we have the pieces in place for these people who find themselves in untenable situations, because that's what this is about. And so we keep going back to, so what does this mean for people? And by doing it on royal assent, the concern is that people will think that it's raring to go, and we haven't really fully built it out yet, and we need the time to do that.
Member Nechako Lakes.
Thank you, Honourable Chair, and I thank you both for the answer in regards to that, because it was a little different to see. And I actually want to thank staff and the member for bringing this thing forward, and government for recognizing its importance and bringing it forward too, because it is about people. As I mentioned at the beginning, I get quite emotional about this issue because of all of the experience, all the things that I've had an opportunity. Unfortunate opportunity to hear about and to be involved in and see. So thank you for the work on this thing, and certainly if there's anything I can do as you're developing regulations and in bringing this thing forward, I'd be happy to be engaged and involved in it.
Minister.
Thank you. I want to thank the member for his questions. I'm assuming that he doesn't have any more. But I want to thank my staff, Wendy, Tyann, and Greg, for being here. And I know it wasn't easy for our staff, for the two staff groups, because it took a lot of bodies to figure out how to make this work. Because what I'm, I guess, most proud of is that we always kept people at the center of it. Like who is it we're talking about? What is it they need from their government, broad government, and in order to deliver for them. So I want to thank the people that are sitting behind me, the people who are sitting at the end here, for their hard work in bringing forward good policy. Thank you.
Member Oak Bay Gordon Head.
In the spirit of that, I would be remiss if I were not to thank both the minister and her staff for working with us on this. The member from Nechako Lakes, I knew that, for his line of questioning, and of course my amazing, incredible staff, Claire, and Evan, but Claire, who really put her heart and soul into this project. And I think what we've seen here is a testament to the good work that she does. So thank you to everybody for bringing this forward.
Okay, so although everyone's made their concluding remarks, we still have a couple of votes here. Shall the amendment to Section 3 by member for Oak Bay Gordon Head pass? All those in favor? Aye. Opposed? So ordered. Shall Section 3 as amended pass? Aye. So ordered. And now we need a mover. Oh, shall the title pass? Aye. So ordered. Member from Oak Bay Gordon Head.
Thank you. I wish to thank the member from Powell River Sunshine Coast for his enthusiastic eyes. And with that, I'd like to move that the committee rise, report the bill M206 complete with amendment.